I'm deeply honored to be speaking today at the third edition of the Athens Roundtable on Artificial Intelligence and the Rule of Law. Artificial intelligence has had an enormous impact on the ordinary human experience. While its initial uses were restricted to more formal domains, progress in natural language processing, robotics, and qualitative reasoning has made it impossible to live without AI in our daily lives. The judiciary and the larger legal community is not immune to this trend, given that AI holds tremendous potential to reimagine our structures of governance and administration. As a judge of the Supreme Court of India and the chairperson of its E-Committee, I would like to take this opportunity to share the Indian judiciary's tryst with technology, and more specifically with AI. The integration of technology with the Indian judicial system began in 2005 with the launch of the e-courts project to ensure technology-enabled courts. Phase 1 of this project ensured the creation of hardware and software infrastructure for about 17,000 courts at the district level, 25 state high courts, and the Supreme Court of India. However, it was not until the COVID-19 pandemic last year that we were truly able to reap the benefits of the technological revolution in our courts. During the pandemic, from March 2020 until November 2021, courts across India have heard a total of 15.861 million cases through video conferencing facilities. The focus of the e-courts project is not just to ensure the availability of hardware and software for video conferencing, but its larger goal is to increase access to justice and provide qualitative, speedy justice through efficient court management. I'm reminded here of the words of Richard Susskind, who in his book, Online Courts and the Future of Justice, notes that technology should bring about a transformation, not just an automation. I believe the Indian e-courts project embodies this principle. The need for a well-functioning judiciary in India cannot be understated, given that it serves a population of 1.3 billion people. One of the significant issues in the administration of justice relates to the pendency of cases in India. 39.72 million cases in the district courts, 5.73 million cases at the high courts, and 69,476 cases in the Supreme Court. It is precisely to provide a data-driven solution to this problem that reliance on artificial intelligence has become relevant to the legal fraternity. The building block of AI is big data. In attempting to use AI for judicial administration, the E-Committee of the Supreme Court emphasized on digitization of court records and launched the National Judicial Data Grid. The data grid is a repository of metadata holding court records of 46.63 million cases. The data grid as a mine of data is helpful, firstly, for smart scheduling of cases, second, for auditing the performance of judicial officers based on their rates of disposal of cases, judicial hours management, and number of adjournments which are granted, and third, for identifying the nature of pending cases and ascertaining solutions by amendments in law or creation of special courts for particular cases. In using AI, the focus of the Indian judiciary has been to ensure improvement in the administration of justice by streamlining existing procedural roadblocks, rather than using AI for substantive decision-making. In India, a few instances of the uses of AI have been as, first, virtual courts for online dispute resolution, for settling traffic violations and other petty offenses, which eliminates this physical presence of the litigator in the court. Second, Artificial Intelligence Committee of the Supreme Court of India has launched a software which relies on natural language processing to translate orders and judgments in English to vernacular languages. Third, another portal was launched in April 2021 for data mining, legal research, and projecting case progress. Fourth, developing AI solutions for automation of scrutiny of cases in the Supreme Court by categorizing cases into different subject matters, identify cases involving a common question of law or fact, and marking objections to defective petitions. We are cognizant of the usage of AI around the world, and in many countries, such as Russia and China, AI provides automated legal advice and timelines for case resolution. In the US, Argentina, and Abu Dhabi, it can predict judicial outcomes based on precedent. AI has also been used in substantive decision-making process, such as sentencing decisions in the US. I believe India can also draw from some of these experiences to ensure efficiency in judicial processes. Government, as one of our biggest litigants, can use predictive technology to assess whether it seeks to pursue certain cases. Transcription of court proceedings, which could assist in criminal trials. Speech translation, such that proceedings conducted in English can be translated into all Indian languages. Increasing access to justice by providing automated legal responses to citizens in agricultural India, which lacks legal literacy, among others. Any technology is not without its faults or blind spots, and AI is no exception to this rule. The substantive justice tools used in the UK and US in determining sentencing decisions in criminal cases have not been adopted in India. These tools have been severely criticized for racial profiling and automation bias. The proponents of AI argue that it can lead to transparent, efficient judicial outcomes, eliminating subjective bias and ensuring impartiality. However, over-reliance on AI without human intervention may lead us to a paradoxical situation where, in the quest for perfect equality, AI-generated judicial outcomes may overlook the very factors that cause gender, religious, caste, and class discrimination. This dilemma has been aptly termed by Chief Justice Sundaresh Menon of the Supreme Court of Singapore in the Goff lecture which he delivered on the 9th of November as the issue of complexification of disputes in the digital age. Elaborating on this issue, Justice Menon has challenged our very conception of the role of judges and what justice means. Is the aim of justice to achieve perfect outcomes through an exhaustive determination of fact? Is such an aim realistic or feasible? And will non-deterministic machine algorithms tasked with this job ease the adjudication process, or will they add to the challenge by failing to recognize the complexities of human behavior? Perhaps going forward, as decision makers and administrators, we will have to question how far AI truly adds value to our work, and to what extent does it exacerbate costs. To quote Justice Thurgood Marshall of the US Supreme Court, in recognizing the humanity of our fellow beings, we pay ourselves the highest tribute. The use of technology, thus, must not obfuscate our primary duty to deliver justice to all humans. Thank you.